Commonwealth versus Rosario.
Good afternoon.
Good
Mr.
afternoon, Your
Kowski.
Honors. I'm a little awkward. I'm up here. If I may proceed,
Certainly.
I'm going to spend 10 minutes talking about myself. I've never had that situation involved here before. I've always been advocating on behalf of a client for whatever reason, either on the civil or criminal side. What I did in this case was follow all of the procedures that I always follow in advocating for a client. And I fall back on a couple of lessons that I learned over the years. One is from a very good lawyer that I worked for. I had the opportunity, who said, read all of the cases. Don't read the head notes, because the head notes can be misleading. My practice has always been to read the case. This was a Franks versus Delaware case. I had read Franks probably a dozen times before. I've read it 3 or 4 times during the pendency of this case. I have also learned from this court on the Commonwealth versus Lawrence that we cannot present a cut and paste brief to this court. So it's not reinventing the wheel. We have to re-look at everything that we've already looked at to make sure, even the statute, I've always reread the statute. If it's a simple assault and battery, I want to look at where the commas are and where the periods are. And I've had the opportunity to do interlocutory appeals before, and I've always abided by and you'll see in the paperwork, I've always abided by Rule 15D. It gives me the timeline. I try to follow that, which I believe I did in this case. And this was a very complex and serious case and involved 17.5 kilos of approximately street value of $2 million in the city of Springfield. It involved very complex factual and legal issues that were found by Judge Mority in a 25, I believe, page written opinion, and I think about 15 of those pages were findings of fact. Based upon my belief that the findings of fact would carry the day in this court if an interlocutory was filed, I didn't believe that the Commonwealth would file an appeal, but the Commonwealth did file an appeal because the case was so complex and involved a lot of my time over the previous 2 years. In fact, I dug out most of the evidence used in the Franks hearing, which was allowed by Judge Moriarty, myself. So when I got the oral strike at the interlocutory petition in, I did what I always would do according to 15D. What my obligation is to read everything, read the cases. I'm not going to get fooled by some reporter who might misstate the head note. So I read cases I had already read before. It was 33 pages. I went through the entire brief, and I had my 7 days to file my opposition, which I sat down and which I did. And I know the statute says if an application has been filed, I have my obligation as an advocate for my client, and I did everything that I did in past practice. Read the cases, read the statute, read the entire memorandums, applications submitted to this court, and I submitted a bill based upon what I believe the fair value of my services are to a client, and this was a private client. Since that time, he has been indicted by the federal court, and Judge Ponza, based upon my work in the Superior Court, asked me if I would take an off-list CJA appointment, which I did, and I would report to the court. Within the past 3 weeks, Judge Ponza has designated this case for discovery purposes, in the federal collateral case, a complex case, which I suggest it is. So I submitted a bill based upon what I believe my time was worth, less than what I would charge a private client, knowing that part of the cost of doing business for the district attorney's office is that they have a budget, and the budget, when they file an interlocutory appeal, part of their consideration is their own budget. That's not my concern, but I know how the process works. So I submit my bill based upon a fair market value of my services, what I have to pay my secretaries, associates in the office, and I've been before this court a number of times. As far as the value of my services, and this is a little bit awkward, but the first case I had in Springfield many years ago, I was given a pre-discovery motion on an understanding of some exhaustive testing, and they called it out there a ship's motion. Well, that was my case in this court. I've been to this court myself many times, hearing my own cases cited up here, Commonwealth versus Sassville, Cater versus the Commonwealth. When this court advises lawyers what the proper procedure is in bringing a double jeopardy case to this court after a hung jury, they refer Led Against 2 Commonwealth versus Cater, which was my case on the double jeopardy after the third trial, and I tried the fourth, and I submitted, I think, 4 briefs and argued 4 times in front of this court, and I argued that case in front of the First Circuit Court of Appeals, in which Sandra Lynch praised and complimented my appellate and trial work in that case. So I think my assignment of $300 an hour was fair and modest compared to what my track record has been, and especially in this case, this was not a hand-to-hand sale on the corner of Maple and Main Street in Springfield in the south end of Maine.
Mr. Klasky, you can
Yes.
argue any point that you'd like to argue. At the moment you're arguing, as I understand it, the reasonableness of your fee.
Well, I thought I argued, going by the statutory language, that's what I did, 15D.
Don't we have to get to the entitlement of... And as I understand the single justice concluded that you were not entitled
Yes.
to a fee, not that your fee was unreasonable. I don't believe the single justice made a determination, did he, that your fee was unreasonable?
Well, I thought I should have been more specific, Your Honor. Pardon me. I just had some sinus surgery, so I'm a little bit distracted right now.
No, it's perfectly
Well,
appropriate for you to...
Pardon?
It's perfectly appropriate for you to argue that your fee was reasonable, but I think the single justice said that
Right.
you were not entitled to any fees, not that your fee wasn't reasonable.
And that, I think that the judge found, based upon the fact that there was no assembly of the record. But I suggest that the record had been started, and there's nothing in 15D that says it has to be an assembly of the record. In fact, Commonwealth versus Gonsalves says that we're entitled to that fee once the Commonwealth has filed an interlocutory appeal and it has been allowed, even if it's dismissed later on, and I cited Gonsalves for you, Your Honor. We are entitled to our fee for the work that we have done.
Mr. Krosky, what do you say? The single justice seemed to base his decision on the fact that there had been no entry of a rescript and no denial of the application, and his feeling that those were the only situations in which fees could be authorized.
Well, I'm citing Commonwealth versus Ennis, Your Honor. For those cases where the Commonwealth has granted leave to file an interlocutory appeal, where it was in this case, but moves to dismiss the appeal before it is decided, a defendant shall direct Rule 15D motion to the single justice within the time limits, which I did. And in Commonwealth versus Ennis, there's this footnote, footnote 2, and that's Commonwealth versus Ennis in my record appendix, 441 Mass 718. On occasion, after it has been granted leave to file an interlocutory appeal, the Commonwealth has moved to dismiss an appeal. In such cases, a defendant shall file a Rule 15D request within 30 days of dismissal of the appeal, which I did. And I think it's Commonwealth versus Ennis or Lennox that also says that once under 15D, we are entitled to our fee because it is black-letter law, that the law states what it means and means what it states. And that's, if you look at the language of the statute, of the rule rather, it says after an application has been filed and allowed by this court, which it was, and that meant that I was under the obligation to begin the work. It doesn't say anything about the assembly of the record. It doesn't say, well, you can wait to see what's going to happen with the Commonwealth to see if they're really serious about this appeal. The obligation is on appellate counsel and as an advocate to begin work post haste, because fustus is the mostus. In this case, you have to get your leverage with your persuasive arguments, and you can't sit and put everything on a back burner, which is what I did because I've been doing this for a number of years. I've had 15D petitions filed and allowed, and this is the first time that I had ever run into this situation, which, as I said, makes it a little bit awkward for me coming in here and touting my skills and my knowledge of the rule. I did everything in compliance with the rule. And under annex, in fact, I think before Gonsalves that there might have been that kind of distinction, but Gonsalves certainly cleared that up. That says that once the application is filed, appellate counsel is entitled to it, and there is a public interest, community interest in doing that, and that is to keep the level playing field in the courts so that the overwhelming resources of the Commonwealth can be met by making the Commonwealth, the district attorney's office, make sure that they're filing meritorious claims of an interlocutory appeal when a defendant, on the rare cases that the defendant wins in the trial court, not to put them to further burdens and further obligation, which is what happened here. I mean, this was a complex case. We had 4 days of hearings, and I'm sorry, Your Honor.
No, it's no problem. It's just a quiet way.
If there are any other questions, I believe that the regulation says the rule says I'm entitled to it, and I did the work, and I'm asking the court to give me my money. Thank you.
Thank you. Ms. Montori?
Thank you, Your Honor. May it please the court, I'm Jane Montori, an assistant district attorney in Hampden County representing the Commonwealth. It's the Commonwealth's position that the single justice ruled correctly that he had no authority under the circumstances of this case to award attorney's fees.
I mean, I don't mean, does it make any sense, does he have no authority, but to have a rule that would say it's only, you only get, even though the defendant has to write a brief and do whatever, if the Commonwealth, rather than have it get dismissed, null process it, you don't get any fees? Does that make sense?
Well, the cases such as Lopez and Sparks show that if the defendant in fact does write a brief, if the case is entered in the appellate court, the defendant writes a brief, there's argument. In Sparks, there was no decision by the court. The issue became moot because the defendant pled. But in Lopez, the court did issue a rescript. In those circumstances, the defendant would be entitled to costs and fees. But that's not the circumstance here.
No, surely the way of looking at this is not how much. The issue is not he's got to expend attorney's fees on all of these things. Isn't the issue once the Commonwealth takes an appeal?
But it's a Commonwealth's position that we didn't take an appeal.
Well, I understand.
And Lattimore says that an application for leave to appeal is not an appeal. And before the appeal, this was a case of first impression. The single justice sent it to this court, which is very unusual, as I'm sure the court will recognize. And before the record could be assembled and transmitted to this court, the Commonwealth null processed the Superior Court case and withdrew this appeal. And so in these peculiar circumstances, which probably don't happen very often, under the rule, the fees and costs should not be paid. The rule says fees and costs are paid upon denial of the Commonwealth's application, while the Commonwealth's application here was allowed, or upon entry of the rescript of the appellate court. And there was no entry of the rescript. There was no entry in the appellate court.
What do you say, though, about this footnote 5 in Commonwealth versus Ellis that Mr. Krowski cited? For those cases where the Commonwealth is granted leave to file an interlocutory appeal but moves to dismiss the appeal before it is decided, a defendant shall direct a Rule 15d motion to the single justice. And then it talks about time limits. Now, would that be analogous to where the Commonwealth initially files an interlocutory appeal but then withdraws it?
Well, it's my reading of the case is that footnote refers back to footnote 2, which talks about the Sparks case and the Lopez case, where the appeals were dismissed, and at least in Sparks before the final decision. And Lopez, the Commonwealth withdrew its appeal the case had been remanded by the appeals court for further findings. When the Commonwealth saw what those findings were, the Commonwealth withdrew its appeal. So it's the Commonwealth's position that that footnote 5 in Ennis reverts back or refers back to those two cases, which
Okay,
again...
fine, but what I'm saying is, wouldn't the situation be analogous if you move to dismiss your appeal some point down the road, or if you withdraw your appeal earlier in the process? Why wouldn't it be the same? Why would the rule be different?
Because of the words of 15D that talk about either denial of the application or entry of the rescript. And if you
But
look
you have
at...
neither of those situations when the Commonwealth has moved to dismiss its appeal after being granted leave to file it.
But I think by definition of rescript in Mass Rule of Appellate Procedure 1C indicates that there's some sort of finality.
Isn't null clausing some sort of...
It's a finality in the Superior Court, certainly. And I also refer the court to its own standing order under Rule 15, where the respondent isn't required to file an opposition to the Commonwealth's application.
So we shouldn't, if the respondent does, they shouldn't get paid? Is that what you think?
That's what the rule says.
Ms. Montorelli, let me ask
In
you
these
this.
circumstances where there is no case entered in the appellate court,
Is it the case, though, that Mr. Krowski filed a memorandum opposing the application, correct?
yes, he did.
Ms. Montorelli, let me ask you this. You have also challenged the reasonableness of the fees, a matter that was not reached by the single justice because of the prior determination that there was no entitlement to fees. If we disagree with the single justice, if and only if we disagree, i.e. that fees are warranted here, and then the issue remains as to the reasonableness of the fees, I assume, although given that you think that fees weren't entitled in the first place, I assume that we could do a couple of things. We could reach a determination ourselves, or we could send it back to the single justice for a determination as to the reasonableness of the fees. If we
Yes.
send it back for a reasonableness of the fees and the defendant is entitled to attorney's fees, it would seem to me that the defendant would be entitled to attorney's fees for your challenge to the reasonableness of his fees. Would you appreciate an opportunity to let the court know, and you don't have to answer me now, if the court determines that there is an entitlement to fees, would you prefer that we refer the matter back to the single justice for a ruling which could then be appealed, during which I assume the defendant would be entitled to further attorney's fees, or would you withdraw your claim for the challenge to reasonable fees? I'm not asking for an answer now, but you can let me know.
Okay. Thank you. And I would rest on my brief as to the reasonableness of the hourly rate and the number of hours spent. I would like to, though, point out to the court that defense counsel was counsel in the Superior Court. He litigated the Franks motion. He responded after the hearings were over. He opposed the Commonwealth's he responded to the Commonwealth's opposition to the motion to suppress. The Commonwealth filed a motion to reconsider in the case after Judge Moriarty issued his opinion, and defense counsel responded to that as well. So under Finney, where it talks about duplication of effort, I would ask the court, if this court were to consider reasonableness of the fees, that the fact that he represented defendant below be considered in the reasonableness of the number of hours. And unless the court has any further questions, I would ask that the decision of the single justice be affirmed.
Thank you, Ms. Montour.
Thank you.
All right.